You're parked at work, normal Tuesday morning. Then a coworker rushes in and tells you there's a federal vehicle in the lot. They ran your plate, and now agents are walking toward the building. What happens in the next 5 minutes determines everything. Every day across this country, people in that exact situation make one critical mistake. They think cooperation protects them. They think answering questions speeds things up. They think handing over documents keeps things calm. But federal immigration law does not reward people who talk. It rewards people who know exactly what to say, what to show, and what to never, ever hand over voluntarily. I've spent years analyzing immigration enforcement cases and studied the Supreme Court rulings that define exactly what ICE agents can and cannot do at your workplace. I've identified the exact legal lines that protect you, and the exact moments most people unknowingly give those protections away. Here is what you need to know. ICE running your license plate is not an arrest. It is the beginning of an investigation. And what you do at the start of that investigation determines whether it ends there or follows you for years. I'm going to break down 4 critical mistakes people make when ICE shows up at work, and the one constitutional principle threading through all of them. Miss it, and you hand federal agents the legal opening they need. Use it correctly, and you walk away protected. This is educational content only, not legal advice. For guidance specific to your situation, consult a qualified immigration attorney in your state. Mistake 1. Thinking a plate run means they already have you. The mistake. ICE ran your plate in the parking lot. Your coworker saw the agents checking a device, looking at your vehicle, writing something down. Your first instinct is to go out there, introduce yourself, explain who you are, show them everything, prove you're not a threat. Most people do exactly this. And most people don't realize they just opened a door that was legally closed to those agents a moment before. The scenario. You're inside at your workstation. A colleague says 2 men in federal vests are in the lot looking at your car. You think, if I go out, if I show them my ID, if I'm cooperative, this ends fast. So you walk outside. You approach the agents. You say, "Is there something I can help you with? That's my vehicle." The agent smiles. "Great. Can I ask you a few questions?" You just volunteered yourself into an encounter that legally had not yet begun. Why people do it? People believe that showing transparency makes them look innocent, that federal agents will appreciate the cooperation and move on. But here is what you have to understand. When ICE runs a plate in a parking lot, they are gathering intelligence. They have not detained you. They cannot detain you yet. The moment you walk outside and initiate contact, you have converted a passive surveillance act into an active, consensual encounter. And in a consensual encounter, everything you say is fair game. Legal reality. The Supreme Court addressed this directly in INS versus Delgado, 466 U.S. 210, 1984. The court held that a person who simply goes about their normal business during an immigration enforcement presence has not been seized under the Fourth Amendment. The key concept the court relied on was consensual. If agents approach you and you voluntarily engage, the encounter is consensual. You are not being detained and you are not being protected. You are participating. The evidence problem. There is no body camera requirement for federal immigration agents the way there is for many local police departments. But agents write reports. Those reports become the factual record of your encounter. If you walked out and said, "That's my vehicle," and answered 3 questions about where you're from and where you were born, that report now exists. That report can be used. The correct move. Stay inside. Do not volunteer yourself into the encounter. If you are inside a non-public area of your workplace, a warehouse floor, a back office, an employee break room, a kitchen, ICE agents cannot enter that space without either your employer's consent or a judicial warrant signed by a federal judge. That is not an opinion. That is the Fourth Amendment as applied to private workplaces, confirmed by federal courts and the American Immigration Council's legal analysis of current enforcement authority. Your employer's public-facing lobby is a different story. Agents may enter that space freely, the same way any member of the public could, but non-public employee areas require a warrant. So the first protective act is simple. Stay where agents cannot legally approach you without judicial authority. Bottom line, never walk toward ICE agents voluntarily. Remaining inside the non-public area of your workplace is not obstruction. It is your Fourth Amendment right in action. But staying inside only protects you until the agents get through the door. And the next mistake is handing them permission to walk through it. Mistake 2. Confusing an administrative warrant for a judicial warrant. The mistake. An agent approaches the building. He's carrying paperwork. He holds it up to the employer or to whoever is near the door. It looks official. It has government seals. It says warrant at the top. Most people, including many employers, immediately step aside and let the agents in. That piece of paper just got ICE access to every employee in your building. But here is the thing. That piece of paper may not have given them the legal right to enter at all. The scenario. Agents arrive at the front of the building. They present a document to the receptionist or manager. The document is Form I-200, a warrant for arrest of alien, or Form I-205, a warrant of removal/deportation. The manager sees the word warrant. She steps aside. The agents walk through into the employee work area. They start questioning people. They find the person whose plate they ran. The encounter escalates. But here is the legal reality that no one told that manager. Why people do it. Almost no one, including many employers and many frontline workers, knows the difference between a judicial warrant and an administrative warrant. They look similar. Both say warrant. Both carry government authority. But they are not the same document, and they do not carry the same legal weight. Legal reality. A judicial warrant is issued by a federal judge or magistrate. It is a court order. It requires probable cause. It will have the name of a federal court at the top and an actual judge's signature at the bottom. Under the Fourth Amendment, a judicial warrant authorizes law enforcement to enter private spaces. An administrative warrant, Forms 1200 or 1205, is issued by an ICE officer, not a judge, not a court. It is an internal agency document that authorizes ICE to arrest a specific named individual if they are encountered in a place where ICE is lawfully present. It does not authorize ICE to enter non-public areas of a private workplace. This distinction has been confirmed repeatedly by immigration attorneys and by the New York Attorney General's Office, which has published official guidance stating that administrative warrants do not grant entry authority into private premises. In May 2025, a federal district court in southern Texas rejected ICE's attempt to use a Blackie's warrant, a civil administrative inspection warrant, for a workplace raid, ruling that such generalized warrants violate the Fourth Amendment and cannot be used to search for people. The evidence problem. If your employer consents to entry based on an administrative warrant, believing it is a court order, that consent is now on record. Courts treat voluntary consent as a valid substitute for an actual warrant. The moment your employer says, "Come in," the Fourth Amendment protection for that space evaporates. Not because agents had legal authority, but because confusion produced consent. The correct move. This is where preparation before an incident matters enormously. Every employee should know, and every employer should train staff, that the correct response when agents present any document is to ask two questions. First, is this a judicial warrant signed by a federal judge? Second, may I have a moment to contact legal counsel before responding? If the answer to the first question is no, or if the document is a Form I-200 or I-205, your employer has the right to say, "We do not consent to your entry into non-public areas of this workplace." That statement should be made calmly, clearly, and without physical interference. If agents enter anyway after that statement, they have done so without legal authority, and that creates grounds for a legal challenge. You personally, as an employee, should say nothing beyond, "I am not going to answer questions without an attorney present." Bottom line, always ask whether a warrant is judicial or administrative. The difference between those two words determines whether federal agents have legal authority to be where they are standing. And once they're inside, the next mistake is the most common one of all. Mistake 3. Answering questions about immigration status. The mistake. Agents are now inside, or you have been approached in the parking lot or near your vehicle. An agent asks, "Where were you born?" Or, "Are you a United States citizen?" Or, "Can I see your papers?" Most people answer. They feel the pressure of the badge, the vest, the authority in the room, and they respond. They think silence looks guilty. They think answering just one question will make this go away. It won't. The scenario. You are in the break room. Two agents enter. Your employer let them in, mistaking their administrative warrant for something binding. An agent looks at you and asks, "What country are you from?" You answer. He asks, "Do you have your work authorization documents with you?" You say you left them at home. He asks, "What's your status?" You say you're working on it. In under 60 seconds, you have given an agent 3 pieces of information that can now appear in an official report and be used in removal proceedings. Why people do it? People believe the Fifth Amendment only protects people who have done something wrong. That is one of the most widespread and damaging legal misconceptions in the country. The Fifth Amendment protects every person on United States soil, citizen, permanent resident, visa holder, or undocumented, from being compelled to be a witness against themselves. Immigration status questions are exactly the kind of self-incriminating questions the Fifth Amendment was designed to protect against. Legal reality. The Supreme Court's ruling in Salinas v. Texas, 570 U.S. 178, 2013, established that silence alone is not enough. You must affirmatively invoke the Fifth Amendment. But once you do, that invocation cannot be used as evidence against you. The Fifth Amendment protects every person on United States soil from being compelled to be a witness against themselves. Federal courts have consistently applied this protection in immigration contexts because the consequences, deportation, detention, family separation, are severe enough to warrant it. There is also a critical practical point. Federal law does not require most people to carry immigration documents on their person at all times. You are not legally obligated to produce papers on demand simply because an agent asks. The evidence problem. Everything you say to an ICE agent can end up in a sworn report that becomes part of your immigration file. That file follows you. If your answers are inconsistent with prior records, those inconsistencies can be used to challenge your credibility in immigration court. If you admit to status or circumstances you didn't have to disclose, that admission is now documented and nearly impossible to walk back. The correct move, regardless of your immigration status, regardless of whether you are a citizen, a permanent resident, a visa holder, or undocumented, the answer to any question about your citizenship, your birthplace, your immigration status, or your documentation is the same. I am invoking my Fifth Amendment right to remain silent. I will not answer questions without an attorney present. Say it clearly. Say it once. Then stop talking. If the agent continues asking, repeat the same sentence. Do not elaborate. Do not explain why you are invoking it. Do not apologize. Invoking a constitutional right is not suspicious behavior. It is the law working exactly as it was designed to work. Bottom line, never answer questions about where you were born, your citizenship, your immigration status, or your documentation without an attorney present. Your Fifth Amendment right protects every person on U.S. soil, and you must invoke it out loud for it to protect you. Mistake 4. Signing documents without legal counsel. The mistake. The encounter has gone on for a while. Maybe you have been asked to step outside, or asked to accompany agents somewhere, or maybe agents are now detaining you. They hand you a document and tell you to sign. They say it's just paperwork. They say it will speed things up. They say it's standard. Most people sign. That signature just changed everything. The scenario. You are being detained. An agent hands you a form. It could be a voluntary departure form, a stipulated removal order, or a statement of facts. He says signing will speed things up, that you won't have to wait in detention, that it just confirms what you already told him. You sign. What you may have just signed is a document waiving your right to a hearing before an immigration judge, or a document agreeing to your own deportation, or a sworn statement that can be used against you if you ever apply for any immigration benefit in the future. Why people do it? People are not told what they are signing. They are under stress. They have no attorney with them. Agents may present the document in a way that feels routine, bureaucratic, like filling out a form at the DMV. But these documents carry legal weight that can follow a person for decades. Some waivers signed under these circumstances bar individuals from re-entering the United States for 10 years or longer. Legal reality. You have the right to refuse to sign any document without first consulting an attorney. This right does not disappear because you have been detained. The Fifth Amendment's due process protections, combined with the Sixth Amendment right to counsel, mean that you cannot be legally forced to sign a document waiving significant rights without understanding what you are signing. Immigration attorneys and the National Immigration Law Center consistently advise that no one should ever sign anything handed to them by immigration agents without legal review. The evidence problem. A signed voluntary departure or stipulated removal order is extremely difficult to challenge after the fact. Courts treat signatures as evidence of informed consent. Even when people later argue they did not understand what they signed or that they signed under duress, courts require substantial evidence to set aside a signed immigration document. The safer position, by far, is to never create that problem in the first place. The correct move. If an agent hands you any document during or after a workplace enforcement action, your response is, "I will not sign anything without first speaking to an attorney." That's it. Not, "I don't understand this form." Not, "Can you explain it to me?" Just, "I will not sign anything without first speaking to an attorney." If you are detained, you have the right to make a phone call. Use it to contact an immigration attorney or to call a trusted person who can contact one on your behalf. Organizations like the National Immigration Law Center and the American Immigration Council maintain hotlines and referral networks specifically for situations like this. Bottom line, never sign any document handed to you by ICE or any federal immigration agent without legal counsel reviewing it first. A signature is permanent. An attorney's review takes hours. The difference in consequences can span decades. The one thing that connects all 4 mistakes. Here is the thread running through every single one of those mistakes. People give away rights they didn't have to give away. They walk outside when they could stay inside. They let agents into spaces agents had no legal authority to enter. They answer questions they were never legally required to answer. They sign documents they were never legally required to sign. Every one of those actions is voluntary, and every one of them triggers a legal consequence. Consent replaces the warrant requirement. Statements replace the need for evidence. Signatures replace the need for a hearing. The law does not require you to make any of those choices. Let me give you the 4 phrases one more time. Write these down. Put them in your phone. Keep them somewhere you can access them if you ever need them. Phrase 1. I am staying in the non-public area of my workplace. I am not going to come outside voluntarily. Use this the moment you learn agents are present and have not yet approached you. Phrase 2. Is this a judicial warrant signed by a federal judge? We do not consent to entry into non-public areas without one. This is for employers or any person positioned at the entry point when agents present documents. Phrase 3. I am invoking my Fifth Amendment right to remain silent. I will not answer questions without an attorney present. Use this for any question about your identity, birthplace, citizenship, or immigration status. Phrase 4. I will not sign anything without first speaking to an attorney. Use this immediately if any document is placed in front of you. 4 phrases. That is the foundation. Stay calm. Stay polite. Do not run. Courts have treated flight as a factor in justifying detention. Do not physically interfere with agents under any circumstances, as that creates separate criminal exposure. Assert your rights clearly, verbally, and on record. Because in this situation, the record is everything. What was said, what was shown, what was signed, and what was refused. All of it becomes the factual foundation for whatever comes next. Make sure that record shows you protected yourself. This is educational content only, not legal advice. For guidance specific to your situation, consult a qualified immigration attorney. If this helped you understand your rights, share it with everyone you know. These rights apply to every person on United States soil. Everyone deserves to know them before they need them. The people who walk away protected are not the ones who talked their way through it. They are the ones who knew exactly what to say, what not to sign, and where the law draws the line. Know where that line is. Stand behind it.